Users on social media platforms are concerned about legislative reforms relating to XRP. One of the most renowned attorneys representing XRP has issued a warning that a jury in a separate trial from the SEC Ripple case may determine that XRP is a security. And further hearing will be held on a matter from 2018 that is unconnected to the SEC Ripple issue. Regarding this matter, there are a few different points of view. As an illustration, there are attorneys who are skeptical that XRP will be classified as a security. Most of the time, a member of the XRP community who is not a lawyer will pretend to be one on YouTube for fun. In what ways does this impact holders of XRP? It is an important question for the majority of people who use social media. X2 attorneys responded to my questions and concerns. On XRP Victory Day, one attorney elaborated on the legal status of the cryptocurrency. The XRP law became apparent on July 13, 2018, and numerous attorneys also remarked on it. According to the news, a judge in California will sue Ripple Securities despite the fact that a judge in New York stated that this is a class action lawsuit, in contrast to the United States Securities and Exchange Commission case. After purchasing XRP and then selling it 2 weeks later, Fred Rispoli alleges that he suffers a loss of either $600 or something of an extremely small nature. Given that the money was not present, his assertion that Ripple is to blame is completely ludicrous. The next year, in June, XRP attorney Fred Rispoli cautioned us to continue our fight against the cryptocurrency. Also, he cautioned that XRP might be able to safeguard in this scenario. There is a plaintiff in the class action complaint who claims that they lost $600 because they invested in XRP. Accusation is connected to the aforementioned case. A long time before he actually did it, it was rumored that he would file charges against Ripple. This is currently a lawsuit filed by a group of people. There is a lack of clarity on the legal standing of XRP, and users of social media are discussing what will occur. Within the context of the Oakland class action, Kearney Rousseau investigated Ripple. Ripple was granted a petition for summary judgment on federal class claims for unregistered securities and state law securities claims. The petition was directed before the court. We are now in a position to decide whether or not the class action litigation over the security status of XRP has been settled. The requirements of all 3 HOTES sections have been satisfied. A single plaintiff's claim may be tried, according to a court's addition. The court stated that the jury is responsible for determining whether or not XRP is a security for retail users on an exchange. This is due to the fact that XRP will soon be legal in California, but it will not be lawful in New York. Continuous pressure on the federal government to legalize cryptocurrencies is something that the Bitcoin community must continue to exert. Please give it a big thumbs up, hit the subscribe button, turn on notifications, and feel free to join our community before we begin. This will provide you with all the information you require regarding XRP. XRP security is planned for the state of California, but not for the state of New York. Workers in the cryptocurrency industry are terrified and do not comprehend. What are the potential outcomes in the event that Judge Torres decides that XRP is not a security, but a jury in California decides that it is? This question was answered by an attorney for Ripple community member Bill Morgan. It's possible that programmatic sales represents a different holding. This term was conceived of by Ripple, and it was utilized by the SEC in the lawsuit. The judge made use of it in the case between the SEC and Ripple. Considering automated sales to be a different holding, he believed that Ripple's programmatic sales of XRP made it possible for traditional cryptocurrency exchanges to trade the cryptocurrency in a manner that allowed individuals like me to purchase it. We are unable to determine who is responsible for our purchases, which makes Ripple contracts that offer investments challenging to access. In the long run, this would be to the advantage of all extra holders, varying sector Ripple. Consider, as a last step, the specific information that was utilized in each instance. It would appear that Judge Hamilton and Judge Torres were provided with differing information regarding the elements that influence the price of XRP. Keep this in mind while you are writing to RISFI, the attorney. In the end, the Ripple case in the Oakland class action raises questions about the clarity of the XRP legislation in California and how it might affect regular people in any state in the United States. In the book, XRP is discussed as a form of protection, as well as how it can have an impact on Ripple. Rizzoli forecasts that the state of California will consider XRP to be a category of security. The issue, according to Attorney Morgan, is not the coin itself, but rather the sales of XRP. In spite of the fact that this disparity is reasonable, the author is bewildered as to how a typical buyer of XRP could make money from Ripple without purchasing XRP from them. There is a possibility that Judge Hamilton will scrutinize Ripple's XPR more than Judge Torres, according to Lori Morgan. Take this into consideration. Garlinghouse has disclosed that he is long XRP, and Judge Hamilton is currently hearing additional promotional statements. The only reason the case can move forward is because of this. This statement made by Garlinghouse during the time that the company sold millions of XRP turned out to be erroneous. The author of this comment does not make any forecasts on the future value of XRP. The author also discusses his own points of view. He is of the opinion that Brad Garlinghouse was selling XRP at an all-time high, yet he should sell it since it could come to constitute an excessive portion of his net worth. On the other hand, the author is of the opinion that the lawsuit might potentially sell all of the XRP if its price reaches a certain threshold. When someone expresses their dissatisfaction with the fact that XRP will be worth more in the future, it does not necessarily mean that the author agrees with them. The fact that Brad Garlinghouse has XRP and a lesser income is another problem with his pay arrangement. Including this in his risky pay plan was this. At the time that he joined Ripple, the value of XRP was approximately 50 cents. Nobody had any idea what was going to happen next. Because he was taking on more risk right now, it was risky for him to work it as a part of his income because it was perilous. The judge, Hamilton, does not appear to be aware of the expert witnesses in the SEC case. It has been said in this testimony that the price of XRP has been following Bitcoin and Ethereum for years, and that this trend is not tied to Ripple's positive announcements. In the process of evaluating the expectations of programmatic buyers, Judge Torres surely took into consideration market tendencies, which had an impact on this information, whether or not judges are able to determine. Whether or not XRP or its sales constitute a security is the primary question, according to the author. To determine whether or not the judges have the information they require to make the appropriate conclusion regarding the Ripple project, clarity is paramount. The SEC's complaint against Ripple in 2020 was different from the securities complaint filed in California. Officials from Ripple have been accused of engaging in fraudulent securities activity. M. Fiegel worked as an attorney for the SEC. He anticipates that the case will be contrary to the SEC's. Even if Ripple were to violate the law, it might not make a difference. It is important to keep in mind that the California prosecution primarily covers allegations of securities fraud against Ripple executives. There are no additional worries that XRP owners have to deal with in the litigation, other than the accusations. As a result, this new trial is based on a lawsuit that was filed in 2018. Judge Torres has decided that XRP does not qualify as an investment. People who are a part of the XRP community query whether or not there is clear legislation regarding XRP and whether or not the decision made by Torres has any impact on other states. Specifically, the SEC is alleging violations of federal securities law, which is the primary cause. Due to the fact that 2 cases from the Southern District of New York are not now before the SEC, other courts do not need to be concerned with them. A victory, but not a victory on a national scale. Despite the fact that the matter is still in the process of being resolved, Ripple will continue to insist that the laws of the SEC apply to any and all federal securities issues that are associated with XRP. Ripple is of the opinion that this will have a significant influence on the decisions arrived at by other courts. It is not a no-brainer, but I do agree with you. To a certain extent, these attorneys disagree. However, it does not appear to have any impact on our instance. In the civil securities fraud lawsuit involving Ripple, a court in California has ordered a trial to take place. A portion of the cryptocurrency company's request for summary judgment ended up being dismissed by the tribunal. The company asserts that Ripple's chief executive officer, Brad Garlinghouse, violated state securities laws in 2017 during a television interview with Rio. The incident occurred in 2017. The question of whether or not Ripple's CEO Brad Garlinghouse misled about the sale of securities will be posed to the jury. He will be found guilty, but before they do so, they must first make sure this is one of the most important lessons that we have learned. Their goal is for the judge to find Ripple CEO Brad Garlinghouse guilty of the charges